Siddiq, yes. Uh, so see if it is. I think it is live on YouTube. So can you generate a YouTube link for me now?
Yes, sir. It is live. I've just shared it on WhatsApp.
Okay, I'm just checking it.
आया तो कोई है नहीं, कॉन्फ्रेंस चल रही है। हिंदी
implementation of the best to get out of मैंने तो स्टार्ट कर दी ना मेरे बच्चे कहाँ है मेरा फोन मुझे
वीडियो
Yeah, is it okay now, Siddhi?
Yes, sir. It is.
Can you check the YouTube? Is it working?
Wait one. Yes, sir. It is.
It is working. Okay, good. So it is time to start now, right?
Hello.
Hello. Yeah, I was supposed to
Nitesh,
welcome.
sir.
Yes, Chindokji. Hello. Hello. Hello.
Nitesh,
Yeah, Himanshu. Is Himanshu online?
कॉन्फ्रेंस चल रही है ना, लेक्चर आए सुनना पड़ता है। चल रहे हैं ना ये लेक्चर पूरा, बढ़िया बुक्स हैं।
Hello. 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 Sir, yes, I have. I'm Madhav. Okay, so should I start? Okay.
आपको अपनी वीडियो कॉलिंग करनी होती है करना चाहो तो कर सकते हैं खोल दूं या आप खोलोगे? मेरी शक्ल गंदी लग रही है जब मैं ऑन करती हूँ, बहुत गंदी। इतनी संभाल के रख रखी थी अंदर। खोल दिया।
औरतों की नहीं कहानियां खत्म होती, शक्ल खत्म होती।
Hello. Good morning, everyone. I'm Madhav Sareen, and it's my honor to introduce our chief speaker today, designated senior lawyer A.S. Chandokji. And I thank Rubinder sir, commonly known as Bobby sir, and Geeta Luthra ma'am for giving me this opportunity. We are indeed privileged to have one of the most venerable and reputed lawyers of the whole legal fraternity as the keynote speakers with us today. His accomplishments are not a surprise to us. He is the former ASG of India, former president of Delhi High Court Bar Association, former principal counsel to the European Union, and the president of INSOL India. Today, he will be educating us on the effect and implementation of Commercial Codes Act, and we are extremely alacritus and eager to bear all ears to him. And now, we would love to hear it from you, sir.
Yes, Madhav is sir here.
Uncle मैंने बोल दिया. But sir has not joined. I don't think he webinar right. Okay. Already presented. Okay, thank you so much. कहते 3 रूम्स आ वेबिनार के. मैंने तुम्हें जो बोला था उससे ज्वाइन करा तुमने, तो तुम देखे अब वो दूसरा वेबिनार टाइम. हाँ, वंडरफुल.
Yes, Madhav. Do we have sir online? Umanshu, can you hear me? Himanshu, can you hear me?
I'm not Himanshu, Madhav. I can.
Yes.
Yeah, I've also visited all the post.
Yes, Himanshu, can you hear me?
I can. Anji. Okay.
Hello, am I audible?
Yes.
Okay, thank you. I thought I got disconnected.
Good evening, everyone. I'm Matharin, and it's my honor to introduce our keynote speaker today, designated senior lawyer, Mr. A.S. Chandok ji.
Nitesh, so we can't hear Madhav sir who was introducing Mr. Chandyok.
Chandok sir, can you hear us?
Yes, I can hear you, but I can't hear Sumit.
Chandok sir, can you hear us?
Yes, I can hear you. Can you hear me?
Yes, sir, we can.
Chandok sir, can you hear us?
Yes, I can hear you, Ji.
The audio on the other Zoom call will not work because otherwise it will echo.
Sir is
Come on, good sir.
Yes.
Good evening, everyone. I'm Matharin, and it's my honor to
yes,
introduce
yes,
our keynote
yes.
speaker
Sir,
today.
can you hear us? Sir, good evening.
Good
Yes,
evening,
sir,
Ji.
can hear
Good
us.
evening to you.
Madhav, now from here onwards you can start.
Okay, thank you so much. Thank you so much.
Sir can hear us.
Good evening, everyone. I'm Madhav Sareen, and it's my tremendous honor to introduce our keynote speaker today, designated senior
Madhav,
lawyer
can you hear us?
Amarjit Singh Chandokji. And I thank Rubinder Singh Sarji, commonly known as Robbie Sir, and Geeta Luthra
Madhav,
ma'am
can you
for
hear
giving
us?
this opportunity. Yes, yes, I can. Yes, I can. Am I audible? Am I audible? Audible? Sir, am I audible?
No.
Yes, yes, you are audible.
Okay, so welcome, sir. Welcome. Good evening, sir. Good evening, sir. Good evening, everyone. It's my honor to introduce our keynote today, designated senior lawyer Shri Amarjit Chandokji. I thank Rubinder sir and Geeta Luthra ma'am for giving me this opportunity. We are indeed privileged that we have one of the most venerable and reputed lawyers between us, our keynote speaker. His accomplishments are not surprising to us. He is a former ASG of India, former president of Delhi High Court Bar Association, former principal counsel to the European Union, and the president of INSOL India. He will be educating us on the effect and implementation of Commercial Courts Act, and we are extremely alacrious and eager to hear ears to him. And now we would love to hear it from you, sir.
Hello, everybody. Good evening to everyone. Everybody is fine. Your families are doing well with this RR crisis. Commercial courts, commercial divisions, and commercial appellate division of High Courts 2015 Act came into force on 23rd of October 2015. And the commercial divisions were sought to be made in the High Courts having ordinary original civil jurisdiction. This act was amended in 2018 and was given a short form as Commercial Courts Act 2015. It went through another amendment in 2019, when normally when you see in every statute that will not apply to J&K was also omitted. The economic development all over the world, including India, there was an increase in commercial disputes, whether they have been covered by the arbitration or by civil suits. There were also disputes with respect to the various intellectual property rights. And we found after the 2G judgment of the Supreme Court, many treaties were invoked for the thought, and one of the contentions raised was that the Indian legal system is not robust enough to meet the demands of commercial world. You all would recall that in White Industries Australia Limited, again the treaty was invoked, and that resulted in the Parliament or the Government of India thinking that we must bring a Commercial Courts Act. And that's where this act was enacted, with the object to address faster resolution of commercial disputes relating to whether intellectual properties or contracts or enforcement thereof, or with respect to arbitration, create a positive change, in particularly with respect to foreign investors into this country, prove to them that we have independent and a responsive judicial system in India. The moment this act was made, a section 3 entitled the state governments to, in consultation with the various high courts, to constitute appellate jurisdictions, both with respect to commercial courts as well as its appellate divisions. A need was felt for 5 high courts that we all know in India who have ordinary original jurisdiction being exercised. Bombay, Calcutta, Madras are the 3 presidency high courts, with addition of Delhi and Himachal. With some people are sending me message, they can't hear me. Can you please look at it, please? Am I audible to everybody? Am I audible to everyone?
Yes, please.
Yes, sir. Yes, sir.
Okay, thank you.
Yes, sir. Yes, sir.
With this speedy resolution in mind, the act was enacted in 2015. As I said, Bombay, Delhi, and Calcutta had already original jurisdiction, which was added to Delhi after 66 Act, as well as Himachal thereafter. We all know prior to the enactment of Delhi High Court Act, Delhi also did not have original jurisdiction, and in fact, we used to have Punjab High Court's bench at New Delhi, adjudicating matters at New Delhi. Once the High Court was established in 66, Section 5 of that provided the ordinary original civil jurisdiction to the High Court. And from here, we started sending our bench to Himachal Pradesh, which ultimately then the Himachal Pradesh also had a High Court established with original site. So there are only 5 High Courts in the country which are exercising ordinary civil jurisdiction, with respect to which the said High Courts will have the commercial courts as well as with respect to the commercial appellate courts. The single judges act as commercial courts, while the division benches happen to be the appellate divisions. But Delhi has also a peculiar situation, because our jurisdiction in the initial High Court is 2 crores. Therefore, the amendment of 2018 also entitled us to bring the jurisdiction above 3 lakhs to the district court, though the term used in the first proviso to section 3, if you all can have a look at it, shows that it will be to a district judge. Consequently, now disputes, commercial disputes up to above 3 lakhs till 2 crores go to the district court, and the above that comes to the High Court. There's a conflict as of today because some feel a specified value in terms of section 12 is still rupees 1 crore, and consequently jurisdiction of the High Court still subsists with respect to 1 crore, 2 crores. The only distinction I can make it at the outset is that after the enhancement of the civil jurisdiction of the pecuniary jurisdiction of the Delhi High Court, we had transferred cases to the district court, including many of the commercial matters. Those which may be left out may still be found being adjudicated in the Delhi High Court. Otherwise, if the original jurisdiction is 2 crores, then all commercial matters between 3 lakhs to 2 crores must really form part of the district judge and not the High Court. Having said that, there is one situation which must be brought to the notice of my August gathering, that in terms of Delhi, the word used in the subsection A is that you will put it to a district level judge, while when you go to subsection 3, it says you may give the jurisdiction of the commercial courts both to the district level as well as judge subordinate to the district judge. Consequently, in the states where we do not have original civil jurisdiction, ordinary original civil jurisdiction, the only way out is that the original civil jurisdiction ordinary is being exercised by the subordinate judges, and since the subordinate judges will have their own pecuniary jurisdiction, the appellate jurisdiction may still be exercised by the learned district judge in each district. One thing is more peculiar. So far as these 5 high courts are concerned, the territorial jurisdiction of the applicability of the Commercial Courts Act is entire Union Territory of Delhi, or for that matter Bombay, or Calcutta, or for that matter Madras. But the said it makes a distinction in other states. The state, in consultation with the High Court, can make this Commercial Act applicable, Commercial Courts Act, applicable to a particular district. As we have these days, we find red areas in terms of coronavirus, where lockdown is complete. Similarly, boundaries can be laid down by the states in terms of the statute to make it even not to entire state, but to particular one. Take, for example, in Punjab, it could be possible, Haryana, it could be possible that only Gurgaon becomes a commercial court's jurisdiction, whereas it may not be in other states. Therefore, the option is given to the state in consultation with respective high courts to create even territorial jurisdiction and make the applicability of this act to a particular territory, not that it applies to the entire state. That discretion is left with the state, and that also goes to the High Court to look at it. That brings me to the next question. What is commercial dispute? Section 21C defines what is commercial dispute. To my mind, subsection 1 to 22 gives almost everything that we come across in life. Whatever is commercial, wherever there is a trade, including IPR, including all kinds of rights arising of a contract, damages, claims arising out of immovable properties would fall within the commercial jurisdiction. The only exception I can think of is if the premises have been let out for residential purposes. I must add here that in Sarabai's case, the Supreme Court had an occasion to look at one of the provisions of section 2 and said, the word used is used for commercial purposes. Consequently, unless the actual user is commercial purpose, it will not fall within the commercial dispute. With all humility at my command, this seems to be a peremptorium. For it omits to look at it that a property ready to be given on lease or given for allotment in terms of a share purchase agreement or an agreement where allotment has been made, it will still fall a commercial dispute and cannot be made that. So the Supreme Court uses the expression to say, I want to interpret this act with purposeful interpretation, but it loses sight of section 12.5, which says, including 2 provisos added to section 2, which said that the very fact that the suit of a commercial nature is also seeking recovery of the movable property or is seeking money with it would not make a difference, would not cease it to be a commercial dispute. It also does not notice that even when there is an agreement with the state or with local authority, even then the dispute would be a commercial nature, irrespective of the parties to the dispute. As long as there's a trade or commerce involved into it, the dispute would fall under the Commercial Courts Act as of today. But as we know, Supreme Court is the law of the land. Till the time we can see its nuisance to be looked at once again by the Honorable Supreme Court itself, we shall follow the judgment as laid down by the Supreme Court. But I must hasten to add that it took us 41 years to the Supreme Court to correct its own judgment, AP Jabalpur. And it took us 10 years to look at Section 9 and its operation under the Arbitration Act. Section 5 was amended in Hindu Succession Act in 2005. We are still looking at a larger bench to look at its interpretation. Consequently, time has come when everybody, each stakeholder must look at the law being laid down, especially our Honorable Supreme Court, to see if the object of the Act is to make the resolution of commercial disputes faster, and special jurisdictions have been vested, even with respect to pending matters on 23rd October 2015, when this commercial court cap came into operation, then the object of the Act would be defeated if we were to restrict the interpretation of the commercial dispute to a particular user being actually used. And more significantly, the word used in the statute is agreement. And to my little knowledge of law, under Section 105, 107 of the Transfer of Property Act, if the actual user is there, then it has to be a lease. And that lease has to be a registered document, has to be on a proper stamp paper. Then why did the legislature use the word agreement? Obviously, its intent was to give an intention or the expression a very wide meaning before it goes to. After having finished this part with the commercial dispute of various nature, whether they are financial, loans, maybe merchandise, even interpretation of a commercial contract between the parties, share purchase agreement, shareholders agreement, joint venture agreement would fall within the commercial dispute under the Commercial Courts Act. That brings us to the question of many people felt that Commercial Courts Act, what changes it has brought about. So the first effect of the Commercial Courts Act, to my mind, is that all matters pending in any court which had commercial inclination and fell within the Section 21C of the Commercial Courts Act had to be shifted from that court and went to the designated court, which was designated as a commercial court, whether it's a state or union territory. Therefore, whether it's a district judge or the High Court, it had to go to original site's commercial jurisdiction, where the commercial courts have been designated by the Honorable Chief Justice. You will find that the Act, while Section 3 uses the expression High Court in the first part of Section 3, when it came to subsection 3, it said Chief Justice of the High Court. So we must make a distinction with respect to when the jurisdiction of the Chief Justice comes. Under Section 3A is where the commercial courts get those jurisdictions, being vested in them exclusively under this Act. This brings us to the next question with respect to what do we do in relation to a plaint that would be filed. Prior to its amendment in 2018, Section 12A was not introduced in the Commercial Courts Act. Consequently, you could invoke the Commercial Courts Act straight by filing a suit. But 12A made a departure, and probably rightly so, because in any commercial dispute, it is possible for the parties to come to a settlement, whether they want to continue the relationship. Because one of the first principles of mediation is that it has to be a win-win situation for both sides. It is possible that those two persons who are gone into a contractual commercial relationship, they like to continue unless they find that the fundamental breach has been committed. So pre-mediation is compulsory before you institute any commercial suit. And that commercial suit would go to a mediation. Again, another problem came in, which we find as legal practitioners, that legal services authorities under the Legal Services Act was given the jurisdiction to have a panel of mediators and also look at how the mediation is to be conducted. To my mind, legal services authority's object is to provide free legal aid, and consequently this goes beyond the object of legal services authorities. But however, in Delhi, we found a solution to it, and that solution was that Samadhan, which has been functioning since 2005-2006, was come into an MOU with the legal services authorities, and all mediation so far as Delhi are concerned are now being done at Samadhan. Thanks that the mediators trained by Mother Samadhan are handy to do this job on the commercial side also. But the fact would still remain that how do you handle this mediation when it comes to other parts of the country, especially where mediation has not taken as much steps as we have done in New Delhi or maybe some other parts of the state in Gujarat or Tamil Nadu. In other states, the mediation is still at its infancy, and therefore it may be necessary for us to have a relook at it. But the fact is, nobody has challenged this position of legal services authority being vested in jurisdiction, so the situation continues. That comes the next position, that under the rules framed under the Commercial Courts Act, there is a form provided, and Form 3 and 4, if the mediation fails, the mediator has to say the reasons for it. I think the very confidentiality involved in mediation itself gets frustrated. If the mediator has to disclose the reasons of the failure of mediation, then the very purpose of having a mediation is failed. Consequently, it looks to me that the rules, mediation rules made under this act also require an amendment, or at least a judicial pronouncement with respect to that. As we have seen, even in the Arbitration Act recently, the Supreme Court said that you cannot have a manifestly arbitrary position with respect to the same. Consequently, here also, to my mind, asking a mediator to give a report and give reasons to breach the confidentiality of mediation. That's one part. The second part is that many of us probably think, because many times this question has been raised in court and otherwise, to say that most of us feel that actually speaking, a mediation under the Commercial Courts Act 2015, as amended in 2018, is actually a conciliation in Part 3 of the Arbitration Act. With respect, it is only mediation. Mediation rules are provided. Who will be mediators? What will be the ethics? How will be the, and it also says in specific words that if there is a settlement, then settlement shall be akin to, or shall be treated, as we have fiction in law, as if it's a settlement award in terms of Section 30 of the Arbitration and Conciliation Act 1996. So let us not confuse it with a conciliation settlement in Part 3. It is actually under Part 1, Section 30 specifically incorporated into the Arbitration Act. That is settlement during arbitration can be arrived at. Parties can give a settlement to the arbitrator who will pass an award in terms thereof. So consequently, this settlement, which is under Section 12A, is actually a settlement, mediation settlement, and is deemed award with consent of the parties. So many would put a question to me that if it's an award, then would it be subject to Section 34? The answer is no. If a settled award under the Arbitration Act, unless we can plead fraud or totally collusion or something with the arbitral tribunal, Section 34 would not apply. And consequently, to this settlement of mediation under Section 12A2, my mind, the Section 34 would not be applicable. Exceptions of fraud, etc., are always available to people. This brings us to the next question. Is Section 12 of the Act, Commercial Courts Act 2015. And that makes a departure from Suits Valuation Act, because it says it provides now what value you will give to that commercial dispute. It lays down its own rules for valuation. Consequently, when you're making a suit or a plaint to be more appropriate, one has to look at Section 12 to put the specified value in terms thereof, and not value the suit in terms of Suits Valuation Act. Having crossed this part, the first question comes in. What should be the plaint? The plaint must have all particulars as we normally feel. The CPC has been amended in terms of Section 16 now, and new amended CPC in terms of the Commercial Courts Act applies to all these commercial disputes. And one of the major situations that have been brought in is appendix in a format has been provided in the schedule to the Act, Commercial Act 2015, which says you will file an affidavit or statement of truth. And that affidavit must contain a declaration by the plaintiff that all that he knows about the facts of the case or material facts have been pleaded. He has filed all documents which are in his power and possession, on which he wishes to rely. And to add to this, the statute and the rules under that schedule provides that these documents shall be attached to a plaint. Unlike a plaint that we found in section 4 or order 4, where a plaint comes before the civil court, normally speaking, we used to make a separate set of list of documents. But here the word used in the statute is you will annex them with the plaint along with a list of documents on which you are relying upon. Consequently, those documents which are annexures to the plaint also need verification in the statement of truth of affidavit that we file. The second part of that affidavit is that the plaintiff must disclose that he has not concealed anything, he has not suppressed anything, and any document even which goes against him has also been disclosed before the court, commercial court to which he is going. So therefore, after 12A stage is crossed, if the settlement takes place, it takes the effect of an award in terms of section 30, subsection 4, as I said. But if no settlement is arrived at, and the report goes to the given to the parties that the parties could not resolve their disputes themselves, the matter goes to the commercial court. The plaint which must be annexed with an affidavit, therefore verifying the facts stated in the plaint. Whereas, if you would recall, when we made an amendment to the CPC itself, it was in an affidavit was sought. But this affidavit is a statement of truth. And as I look at the situation going by the years, the time has come, as we have it in England, that the solicitors as well as the lawyers will have to file an affidavit that they have seen the prima facie evidence in support of the averments made or the allegations made in the plaint. But that's not the subject matter today, or it does not come part of the Commercial Courts Act as of that. Therefore, the party claiming the plaintiff or one of the plaintiffs will have to make a verified statement on oath. And the last paragraph of that format provided in the appendix is that I am conscious, the deponent says, that if any statement is found to be false or incorrect, I'll be entitled to be proceeded against in accordance with law, which could be a contempt, which could be a forgery, which could be a 340, which could be any proceeding that are available to a court in accordance with law. Therefore, care has to be taken in commercial courts disputes that parties disclose everything, and parties must file on record all documents in their power and possession. Having filed your suit comes the next part, that the suit can't be instituted. I should have dealt that earlier while dealing with 12A. Namely, if you are not seeking any urgent relief, then you have to go to compulsory mediation under 12A. But if there is an urgent relief sought, you can straightaway go to the court. The court may then exercise its jurisdiction, maybe under section 89 of the Code of Civil Procedure, and say parties may now go for resolution of their disputes before the mediation. So mediation pre-litigation, mediation post-litigation is also possible. The only exception is you are seeking an interim relief. Now, as a matter of routine, we found that in all commercial matters, a plaintiff would file his application under Order 39, Rule 1 and 2 and get it listed. But on a judicial scrutiny by our honorable judges, many suits have been read to be that they are not urgent. They could have waited for the mediation to continue and complete. And fortunately, the mediation for the first time brings in a concept that the limitation will also stop. Therefore, a plaint must satisfy the precondition of mediation today, unless it's asking very urgent relief, and that relief the court is ready to look at once the plaint is filed. You would recall, in terms of section 80 of the Code of Civil Procedure, you have to issue a notice to the government or a local body, but you could take leave of the court to file a suit without going to comply with section 80. So it's the same way, you must, though there was no leave provision here, but if the plaintiff is seeking an urgent relief, he can straightaway invoke the jurisdiction of the Commercial Courts Act. The moment service is effected, two things have to happen. The limitation for the defendant begins. He must file his written statement within 30 days, and the maximum period subject to extension being granted by the commercial court is 120 days and no further. You all are aware, Section 34 of the Arbitration Act, where you file your application within time prescribed in 34. The court has no jurisdiction thereafter to extend the time if you cross that limit. So similarly, the Supreme Court has now held the provisions of the Commercial Courts Act insofar as it relates to the extension of time to be granted to a defendant in relation to a filing of a written statement. He must abide by the timelines given in the statute. Once written statement gets filed, admission to trial takes it. A new Order 11 has been brought in by the amendment of Commercial Courts Act, by which you could ask for not only discovery of documents, but even ask for interrogatories. Normally, the experience shows this provision has been very rarely used, but I'm sure in the commercial disputes, this shall be used with priority for you. One would be able to narrow down the dispute because the stage under Chapter 13A comes in once the pleadings get over, admission denial is over. It comes before the court, and the commercial court at that stage may decide that a part of the claim of the plaintiff is admitted by the defendant, and therefore proceed to decide that case without going into issues or going for case management in terms of Chapter 15A. An additional right has been given to the plaintiff that after service of the defendant, if it finds there are documents which is in power and possession and filed on record, on which there could be admission of a part of the claim of the plaintiff, then the plaintiff can also invoke the jurisdiction under the Commercial Courts Act, requesting the court to have a hearing in terms of the said chapter and pronounce a judgment with respect to the claim of the plaintiff. Now, please consider that unlike Order 12, Rule 6, the specific Commercial Courts Act schedule provides what should be the plaintiff's pleading if plaintiff was to invoke the jurisdiction of a summary judgment, and what should the defendant do with respect to the same. So compliance of those two, to my humble view, would be required, unlike what we do in Order 12, Rule 6, and not specifying all admissions, not specifying the documents. And in fact, in one of the matters of Supreme Court, Justice Bhanumati said that 12.6 can only be looked at. You can't look at the pleadings, you can't look at documents, which of course the view again, with all respect, is by the Supreme Court, but that's contrary to the established principle of fundamental principle of Indian law. But having said that, once we finish with the summary jurisdiction, the next question comes in for us is now the case management hearing begins. The case management hearing brings that a court can call upon the parties even at that stage, as I said earlier, that though no pre-litigation mediation took place, if court finds there are elements of settlement, what we see the language from Section 89 of the Code of Procedure, court may call both the parties at the stage of case management meeting and examine both of them and see if it is possible to resolve this commercial dispute. But timelines are very important, and in every commercial dispute, it is the time that is the most important. 6 months' time is given under the Commercial Courts Act for parties to complete the trial, complete everything with oral hearings, so that, and if this case management order is violated, then court can either condone the delay, or can dismiss the suit, or can allow the suit. And the subclause 3 provides that if it finds there is a willful and repeated default, then the consequences are much larger than the first 2 clauses. Consequently, stricter lines have been laid down, strict rules have been provided, strict procedural rules have been provided, and timelines have been provided which need to be followed. This would then render in 90 days, this High Court or the Commercial Court is obliged to give a judgment, whether it's a district judge or for that matter, the High Court. And once that judgment is pronounced, the question comes in of appeal. There's a dispute or a conflict of opinion in the 3 benches of Delhi. Bombay has taken another view now. Madras has also taken a view. But as far as the Delhi view is concerned, the two conflicting opinions are one led by Justice Badr Ahmed, as the Lordship then was, saying that an appeal under Section 13 of the Commercial Courts Act would only lie if it fell within the four corners of Order 43 of the Code of Civil Procedure. Order 43 Code Civil Procedure is extremely limited, and consequently, looking at the statute as it remains today, the Commercial Court Act does not allow a revision, and it also says, as we have in Section 16 of the Arbitration Act, that if the arbitrator decides it has jurisdiction, it will proceed with the arbitration, which will result in an award under Section 31, and then you can file under Section 34 a petition challenging that order under Section 16 also. Similarly, under the Commercial Courts Act, if there's you filed an interlocutory application, so the defendant moves and says this court has no jurisdiction, or it says the dispute is not commercial, and the commercial court comes to the conclusion that it's commercial, that it will continue. Such a challenge, even to the jurisdiction, is not available even from a district court by way of revision under 115, or to my mind, even 227, because jurisdiction itself has been excluded. And unless there's an error of jurisdiction, to my little knowledge, Article 227 will not come to a head. Consequently, the appeal becomes important against decrees. An appeal must challenge all those interlocutory orders which have come during the way of the proceedings of the commercial court in order to make a composite challenge before the appellate division of the High Court or the appellate court, commercial court, in terms of the district courts in other states. Now, interesting question that comes in is, where would that appeal lie? Under what? If there's a judgment and decree, an appeal would lie. But whether appeal would lie against every order is a question that I was debating earlier, when there was a conflict of opinion. Justice Badal said Order 43 is the only provision under which you can file an appeal. Whereas Justice Bhatt, when his lordship then was, decided that if the litigation is prior to the date of the coming into force of the Commercial Courts Act, then a right of appeal was vested in a party because the litigation started prior to that. It lies upon Vodafone judgment of the Supreme Court and say a pre-existing right has not been taken away specifically by the Commercial Courts Act. The matter is in the Supreme Court. Some appeals have not been preferred. However, two matters are still pending in the Honorable Supreme Court. There is no stay of the operation of the other of the judgments. Consequently, we shall await from the Supreme Court as to what do we get. Now, the effect of all this is, first, that all commercial disputes pending on the date when this statute came into operation in 2015, as of date, till date, will stand transferred to the commercial divisions of the commercial courts. All appeals will become commercial courts. A question that was one of the reasons given in one of the judgments was that if the suit has not been converted into a commercial suit, then what will be its consequences? The court said mere nomenclature of the suit would not make a difference if the dispute is commercial. And that's exactly when I drew your attention to Sarabhai to say that a dispute has to be commercial. It should be connected with, have some nexus with commerce and industry, some nexus with commercial disputes, which is commonly a businessman would look at it. And consequently, an appeal would lie only if this Order 43. However, a conflicting view with respect to the cases that were pending prior to 2005 is certainly possible.
मेरे तो पाँव फट रहे हैं, पाँव में दर्द होने लग गया है करके सर्दी।
So the next part is, first part is the effect of this is that all commercial disputes now
वो ठीक हो गया क्या?
would go to
ये मैं तुम्हारे को आज पैक वो लगा दूंगी, उससे सारा कर देगा, ऐसे मत करो।
Commercial court and would not go elsewhere. The second part is all interlocutory appeals, what we used to have FAOs.
आधा घंटा पढ़ना पड़ेगा।
Consequently, it will not be possible to have any interlocutory appeals. The third is that against a decree or a judgment, an appeal would lie. Would then look at it, whether the nature of the dispute, whether in interlocutory or otherwise, was within the four corners of the statute. I would wait for the questions to come from my eminent people who are listening to me. I will wait for the question answer session to begin. Thank you very much.
Hello.
So do we have any questions lined up?
Hello. Hello.
Hello.
Sir,
Yes.
what about the suits which are under Order 37, like the suits under summary trial, whether under the commercial
Yes,
act?
you are
नहीं
audible.
है
Yes,
जी
you are audible.
Yes, when you are already under Order 37, if those suits have you have got a leave to defend, then if you see subsection 7 of Order 37, then they become like ordinary suits before the Commercial Courts Act comes into picture. But post Commercial Court Act, if leave to defend has been granted, then you will be entitled to move and it will get transferred into commercial court. But however, Chapter 13A of asking a summary judgment once again would not be available in a case where Order 37, in Order 37, leave to defend has been granted by the court. So it must await the case management, trial, and pronouncement of judgment after evidence.
Hello.
Yes.
Sir, the question is that post Commercial Court Act,
Yes.
the litigation which was earlier available under Order 37
Yes.
would not be able to file under Commercial Court Act because there is no
Yes.
provision under Order 37 under Commercial
Therefore,
Court
I
Act.
said prior to commencing into force of Commercial Courts Act.
No, it's a post one. It's a post
Well,
one. See, it's
post, you will have to take aid of, it is a, after you complete your pleadings, after the defendant is served, you may invoke the jurisdiction of the commercial court to say, I want a summary judgment. And the court may at that stage come to your aid to say, yes, this is a case which requires, he has no possibility of the defendant succeeding in his defense and consequently pronounce the judgment forthwith. That's exactly what I'm saying, without going into Chapter 15 or Section 15, Order 15A, where you have to go for a case management. So there is a provision now in the Commercial Courts Act, though it may not be termed as Order 37. But in Order 37, you still will be suits in a contract which is not commercial. You can still bring under Order 37. It's not that Order 37 has become obsolete. But yes, in Commercial Courts Act, after 2015, we will have to file a suit under the Commercial Courts Act, go for that and file, ask for a judgment under Order 13A, where you can ask for a summary judgment from the court.
Hi, sir. Good evening.
Thank you, sir.
Thank you, Lee. Thank you very much. Thank you, everybody. Thanks, all of you, for giving me this opportunity to be amongst you.
Sir, if I may ask just one last question.
Yeah, please ask any questions, sir.
This is regarding the pre-mediation and settlement. The
Yes.
aspect regarding the sort of bringing a moratorium on that limitation while the mediation is going on.
That's
So
right.
what will be taken as a starting point? Because the words used is while the parties remain occupied. So what will be the starting?
I, for one, will have to look at it to request you to please see when the parties for the first time appear before the mediator, the limitation should begin, normally speaking. But if I would take Section 21A of the Arbitration Act, the moment I give notice of mediation to the legal services authorities, who then takes time to appoint a mediator, mediation must begin from the date when the plaintiff has moved an application for asking for a pre-litigation mediation. Till the mediation report goes, either saying it has settled or it is not settled.
Thank you, sir.
Sir, one more and last question.
Please ask any questions.
Sir, can you hear me?
Yes, yes, I can hear you.
Sir, can you hear me? Sir, yes,
I can
this
hear you.
is
I can hear you.
in
I can hear you.
mediation in this commercial is again with regard. Yes, sir. This is again with regard to the pre-mediation litigation. Sir, how far you see that this is effective in the Commercial Courts Act, since we already had an idea of this samadhan mediation even after the filing of the case. So indeed, isn't this process is a wasting of a time of the parties in going into this pre-suit mediation when the options is already
There
available
is
to them
no
after the filing
provision
of the
in
litigation?
law. There is no provision in law for a pre-litigation mediation. Section 89 only comes into play. It is post-litigation. You've already gone to court, and court finds there are elements of settlement, of course, with the consent of both parties. Now, in this case, it is necessary for you to examine that why did the legislature thought 12A should be introduced? So that if people want to continue their relationship, they may sit in the mediation, modify, maybe restructure their agreement. Now, look at the COVID situation. Now, this is extraordinary. The court is today looking at special equity. Now, in a given case where you have not put a force majeure clause, it may be possible for you to put a force majeure clause during mediation and either condone the default already made or make some provision with respect to the same. So in a commercial dispute, pre-litigation becomes important role to play. Though we already had Samadhan. It's not that Samadhan was not there. It's not a question of Samadhan. It's a question of pre-litigation in every part of the country. That is important. The entire economic consequence, pre-litigation mediation is playing an important role in the country. Anybody else?
Hello.
Hello?
Sir, I just wish to
Thank you
ask.
so much, sir. If anybody else their question, they can.
Yes, I'm asking only one question to sir.
Yeah, please ask.
Sir, there is I presumably there is a concept of filing joint schedule of documents, joint schedule.
Yes.
After admission denial process.
That's right.
It's proving to be very difficult to bring all the parties together because ours is an adversarial system, and I have come across difficulties in finding all the parties to come on the same page and consent to give their signatures. Sir, how to go
I
about?
want to understand if the admission denial has taken place and supposing plaintiff's 20 documents are admitted by defendants and defendants 15 documents are admitted by the plaintiffs, a compilation doesn't require any other signatures. It's already admitted, denied on affidavit.
Absolutely, sir. But somehow
you're only making a compilation for the purpose of court knowing these are admitted documents between the parties.
Right. So, sir, only the plaintiff can file this compilation?
Yes, I'm sure you can take leave of the court to say the defendants are not signing it. Here is an admitted document. Allow me to file it, and I'm sure they will be allowed by the commercial court.
Right, sir. Right. Thank you. Thank you, sir.
Thank you.
Question, participants?
Thank you so much, everybody.
Any other question with the participants? Thank you so much, sir, for the wonderful lecture which you have delivered on this Commercial Courts Act. I think after today,
to see you. We hope this comes to an end. We are able to see each other soon. Thank you, everybody.
Thank you so much, sir. Sir, after the today's lecture, I think the Commercial Courts Act have been made so easy to everyone. Sir, lecture series on law is very thankful to you for your time and sir explaining this technical Commercial Courts Act. Thank you so much, sir.
Giving me an opportunity to be amongst my friends.
Sir, we are obliged to you, sir, for your kind words. Thank you so much, sir.
Thank you so much. Thank you so much. Thanks a million. Thank you.